It's 10:05. Steve Martin with you, ABC Radio-Melbourne and ABC Victoria, and we're about to have some legal talk back on the program. David Whiting is Melbourne's solicitor. He is with me in the studio, and we have a couple of things to talk about, but he is here for your calls this morning. And the number, of course, is 1300 222 774. 1300 222 774. If you have a legal question to ask David this morning, we have some homework as well to get through, but texts you can do on 0437 774 774. But it's better to be able to talk to David on these sorts of things. David Whiting, good morning to you.
Good morning, Steve.
Now, just before, there's a couple of calls are starting to come in, and there's plenty of room on the open lines this morning, so people will get through hopefully relatively quickly. You were just saying, while at the end of the news, there's a bit of an inquiry looking into legal fees that's been going on. Is that right?
Well, no, it's about to start. George Brandis, the Attorney General, has indicated that there will be an inquiry into legal fees in class actions. Mm-hmm. Now, you need to think of a class action as being an action that might represent 1,000 or thousands of people. And in this particular, what the trigger was, there was a class action arising out of the bushfires that resulted in a settlement sum of $494 million, of which the lawyers took 100.
Okay.
100 million, I think, was the report in the paper. So that's near enough to 20% of the fees, a little over 20% of the fees. And the question becomes, is that reasonable or unreasonable, and how do you assess costs? Because it's very rare in a class action for it to settle on a plus costs. The plus costs to be ultimately resolved, it settles on a single figure, in which case I suppose what you do is you reward the lawyers for the work that they've done, for the money that they've spent, and they also get they might lose the class action, in which case they don't get any money, because all of the agreements they've reached with their clients are almost always on if we don't get any money, you don't pay us anything in a class action. Yep. So you have to ask in that situation, what's a method of determining an appropriate level of costs for a class action? I would have thought there'd be hundreds of lawyers over the course of the matter, hundreds of other non-legal staff, lots of experts, all of whom will have got paid, all of whom will receive their fee out of the money that went to the lawyers. So I find it fascinating. We're about the only profession whose role in giving you a bill is to tell you how you can avoid paying it.
Can you just explain this to me? How do most class actions start? Because sometimes it seems that those in the legal profession go spruiking for someone They do. To start a class action and then for others to join. Or does it ever start with someone like me coming to a lawyer saying, hey, this is wrong, and the lawyer's perhaps suggesting, well, we could do this as a class action?
It can happen that way, but it's normally the lawyers who would see that there is a potential for a class action in a particular set of circumstances and would then, well, even if it was Steve Martin walked into a law firm and says, I think that this is wrong and ought to be dealt with, somebody then needs to start finding the members of the class action. Because it could be a class action with 10 people, but you'd probably rather run a class action that represented everybody who was affected. Yeah. So that's the way it works. And sometimes you actually get multiple class actions on substantially the same issue. And at some point there needs to be a rationalisation of which one continues and which one doesn't.
And some members of one of the other class actions might all join onto that one. Can that happen?
Yeah.
So they all combine forces.
That was where you'd ultimately want to end up. Why do you want to answer the same question 3 times in different proceedings? You don't.
Okay.
Hideously expensive. And then there's a question as to, well, which class action are you a member of? Because as a matter of logic, you can't be in more than one if the loss is the same.
Right. Okay. All right.
So another thing that I found fascinating in the law this week, there was a question that the Supreme Court needed to answer about bankruptcy. And it talked about a lawyer who was declared bankrupt in 2014, and he commenced proceedings after his bankruptcy finished for legal fees that he had for legal fees he wanted to charge for work he'd done while he was bankrupt. And they went to a magistrate. The magistrate says, look, I'm really very sorry, you can't commence those proceedings. It needs your trustee in bankruptcy. So we went off to the Supreme Court, and the Supreme Court said, yes, you can. You have the ability to commence proceedings in respect of your life after the bankruptcy started in your own name and don't need your trustee's permission. There might be an argument about how much of the money the trustee might be entitled to, but that's a different question.
Yeah.
And I had one bit of homework.
Yep.
Jennifer from Glen Iris. There was a house that was being renovated nearby, bought about 18 months ago. Renovation is intermittent. Do they have to pay the residential land tax? The answer is yes, they do. If it was habitable before the renovation work started and will be habitable after it completes, then we will assume that at all times it was vacant residential land. Now, the trigger at the start was habitable, was a home before the work started. It means that way you don't catch a new home.
Okay.
All right. So you don't catch a residential property that's in the course of construction or a residential property that's being used as a display home. And the other one is, of course, is that it doesn't catch properties the ownership of which changed in the year.
Oh, okay.
All right. That's if you bought a property in September, you don't need to worry about this.
Okay. And just to reiterate, in terms of the residential land tax that we're talking about, this is only applicable
in 12 municipalities, which
in the
is
city.
Yeah, basically the ring around Melbourne.
Okay. So for listeners in regional Victoria this morning, you don't need to worry about that if you've got an investment property or somewhere sitting vacant.
Well, it might be an investment property, but so yes.
Unless it's in those 12 municipalities.
In the ring. Yep.
Now, we've got a few calls on the line. Let's start with Bert in South Gippsland. Hello, Bert.
Hi. Look, thanks for taking my call. Look, I'm deputy chair of a church. Oddly, even though I live in South Gippsland, the church is in East Melbourne, and it's around 60 years old, David.
That's not a very old church, Bert.
Well,
if you said 160 years old, I could understand. Yep.
Sure. But look, we're a bit concerned. There's major construction works being undertaken adjacent to the church by another property owner.
Yes.
And they will commence in 2018. Now, the construction firm want to build a gantry over our car park to facilitate their construction work.
Yes.
And offered to pay us for that.
Yep.
And we assume we'd go into some sort of an agreement with that. But look, we are concerned about any adverse impact on our building.
Yes.
We took photos of the church.
You want more than that, Bert. You want something that's called a dilapidation report.
A dilapidation report, okay.
Yes, and I know that your church is no doubt pristine and perfect, but what we're trying to do is set a baseline for dilapidation prior to the commencement of the... So we want to know what happens during the course of construction. Are there cracks that open up? Are there bits of plaster that fall off? We want to know the condition of your property before the work starts next door.
Okay,
now, the next thing you would also want to do is you would want to talk to the building surveyor who's giving them the building permit to talk about protection works. Okay. So what protection works are required to your property? You get, in strict theory, if they don't come into your property, they may not need to do protection works. But if they're digging down and the digging down is likely to affect your foundations, you want to know about it. So your building, I would be approaching the building surveyor, so approach the builder and say, what's proposed in relation to protection works for my property?
Okay.
So dilapidation report, protection works, an agreement for the gantry, and there was a case that was decided last year in the Supreme Court that talked about cranes. And the question as to whether or not I can allow the crane on my building site to go over the top of your property. Okay. And it was resolved in favour of the person who didn't have the crane.
Okay.
All right.
Okay.
So the crane can't go over the adjoining property?
Well, that's not without permission, no.
Okay.
So there was a case last year that determined that. So they're the kind, and my view would be, if there's a big construction in East Melbourne next to your church, it's likely to involve at least one crane.
Well, they have said that. You're absolutely correct.
So that's another thing that you need to look at, and so you would also want to make sure there's appropriate insurance and everything else. Okay. That's where I'd start.
Okay. And sorry, the dilapidation report, do I get that from the building surveyor, or where do I get that?
Well, you'd really... I was involved in one in Hawthorn last year, and we got the dilapidation report and presented it to the builder next door. but it might well be. I mean, sometimes it's them, the other side, the one doing the work, who says we need to get a dilapidation report so that we know what claims you might make against us. But even if you might even agree as to who was to do the dilapidation report, they tend to be rather large and have lots of pictures.
All right, Bert, hopefully that is of more than just a little bit of assistance, a lot of assistance for you. So, Bert in South Gippsland, thank you. Anthony's in Lilydale. Anthony, good morning.
Guys, I've got a blocked stormwater drain, and we've worked out that it's a route from the gum tree that's on the nature strip. And I'm just wondering if that's my job to pay for to get fixed, or if that's the council's job to deal with.
I would think it was the council's job.
Yeah, so I've gone to the council, and I've already had someone inspect it to say, yes, it's definitely one of the routes, and the council's come back to say that it's got to be at my cost because I'm in charge of the stormwater drain.
Well, I suppose my question would be, was the stormwater drain there before the tree, or the tree before the stormwater drain?
Yeah, I assume that it's probably, being back in the day, they would have put the stormwater and the trees all in one hit, because the estate's probably about 25 to 30 years old.
All would have gone in at the same time. Yep.
Yeah.
I think it's their tree which has grown into the stormwater.
Yeah.
I would make the problem theirs.
Yeah.
If you don't get what you want, talk to the Ombudsman's office.
Thank you very much.
Victorian State Ombudsman.
Thanks, Anthony. Does it depend where the stormwater drain, if it's on your property or on council property? Does that come into it?
Well, if the stormwater's on your property,
yep.
The issue, if it's on your property, the issue will be is that the council is supposed to keep its roots on its property.
Okay.
So at which stage I'd come along and say, well, it's the council's fault because it's come onto it's entered onto my property, and I want you to take it away, and I want you to prevent the damage that it's causing. Where you've run the stormwater through council property, then through the road reserve, which will be council property, I would say that they still ought to keep their trees away from your stormwater.
On the text service, thanks very much for the homework done. That's from Jennifer in Glenara. So, now, Al in Port Melbourne, hello.
Yes, good morning. Thank you for taking my call. Look, I'm assisting with the settlement of the estate of my sister-in-law, and my wife has been going through the bank statement. She's found a statement which had an amount of $50,000 sitting in the account.
Yes.
And then there is an entry which says, account closed in error, and there's been $47,000 deducted out of the account, leaving a balance of $3,000.
Yes.
Now, this doesn't make any sense to her, and she's contacted the bank and said, well, what's the other side of the $47,000? Where did it go? Account closed in error. It doesn't make any sense. And they've come back and said, well, this happened over 7 years ago, madam, and we can't help you. Sorry.
Which is quite possibly right.
Well, I'm sure that the banks keep records which extend beyond 7 years.
Oh, if only that were true, Al.
Well,
I've been looking recently for bank statements and mortgage documents going back a few years, and everybody shrugs at me and says, can't help. You might talk to the Financial Services Ombudsman on the issue.
Yes, we've done that.
And what do they say?
Well, they said, look, it's over 7 years old. But I've also spoken to people from the bank, and they said, no, the bank can go back 20 years. That's just, they just need to take the time and the trouble to do that. And
well, let's assume that they can, Al. It doesn't mean that they necessarily will. The Limitation of Actions Act imposes a time limit of 6 years on simple contracts. That is, that you can't enforce a breach of a contract or take action as a consequence more than 6 years after the right arises or the damage occurs. So you're going back 8 years and you're simply saying to them, I may have a cause of action against you that someone has, in the eyes of the law, slept on for a very long period of time. So it may well be that even if you find that there was an inappropriate dealing, which I would suggest is unlikely, but even if you do, you're probably out of time to commence proceedings against it. It doesn't mean that there couldn't be a criminal action. It just means that there couldn't be a civil action.
Well, it's interesting because my sister-in-law was not financially very astute, and she dealt with one of the bank's financial arms.
Yes.
And this all took place at around about the time that there were some very strange things happening in the bank. And in fact, there have been several prosecutions, and all we really want to know is where did the $47,000 go? What was the account that was closed?
Yep, I understand why you want it. Question, I don't believe you have a right to insist upon the bank putting the time and effort into showing you.
All right. Thank you, Al. It doesn't sound like it's necessarily the advice you wanted to hear, but it's only 6 years. I guess that's all there is. Alex is in Oakley. Alex, good morning.
Good morning. I'll shoot with my question. Now I'm challenging a speeding ticket in court. Question number one, do I need a lawyer there?
Well, what's your challenge, Alex?
In essence, I'm not really challenging the specifics. I just want to plead for leniency because it's 30 kilometres over. So that means I'll have to...
Is it automatic loss of licence, 30 kilometres over the limit?
Yeah, it's 1 month. Suspended.
Yes.
So because of my clean record, because I haven't had any other speeding tickets, I'm asking for leniency plus the fact that I really need my driver's license. So do I need a lawyer? Do I go there by myself?
Alex, as a matter of law, you're not required to hire a lawyer to represent you when you go to court. You're entitled to do it on your own. When are you going to court, Alex?
25th of January.
Okay, well, I can tell you we're back the week before. You can have a talk to us then.
Okay.
But my view would be you actually need to look at the Road Safety Act and you need to have a look at what your options are in those circumstances. It may be that the magistrate has no discretion. I don't know. But you'd also need to explain why on that day you were 30 over the limit.
Yeah.
All right. Now, that to me would be your biggest hurdle.
Yes.
30 over the limit is considered to be an excessive premium over the speed limit.
Yeah.
All right. Now, if it was a 60 limit that was reduced to 40 and you were 3 minutes after the time change, that might be an argument. But, if it was I'm doing 130 in a 100 zone, I don't see that as a good argument.
So leniency may not apply, and it depends. Do you know, David, does the length of time without a fine, so a good driving record, does that play much of a role, or is it more on the circumstances
It might,
of the fine?
but what you're doing in those circumstances, Steve, is you can actually go to the prosecutors. You can go to the camera officer and you can simply say, could you look at my driving record? I've been really, really good. I've had nothing for 10 years, 15 years, whatever it is. These were the particular circumstances, and sometimes they withdraw them.
Yeah. Okay.
Not often.
Yeah. So, Alex, as David was saying, back the week before you go to court, you can have a think and do some research, have a chat again on the radio if you want to. Let's go to Northcote now, where Bill is on the line. Hello, Bill.
Yes, hello. Thanks for taking my call.
What have you done, Bill?
Now, look, many years ago, I built a lean-to out the back on my house because it was only 2 bedrooms. When the boys got big enough, you just did like a lean-to veranda thing for them, you know what I mean?
Yep, yes.
And I didn't get council approval at the time. It was just me and my mates on the weekend. And then, about 30 years or something like that ago. Now I want to sell the house. Am I going to get into trouble for not getting that council approval?
With whom?
With whom? With the council, I mean.
The council still won't know unless Darabin monitors the bills from Northcote. We're okay.
But when I sell the house, I see. When I sell the house, will they say who built this or something? No?
There's a series of warranties, and one of them is whether you got permits. That you don't make a warranty that every piece of work in the property's had permits for it. You've got no obligation at law to tell your purchaser that you've made some changes to the property without permits. Now,
is that right?
We're talking about something 30 years ago.
Yes.
You might choose to do nothing. You might choose to get a permit for the work that's been done, but that's going to come with so many bells and whistles and hoops that you need to jump through. I probably wouldn't.
Can I just
why not put it, if you're worried, why not put a special condition in the contract that says The lean-to out the back was constructed in about 1987 without a permit, and we don't have any paperwork for it.
All right, then.
So the purchaser
in a
knows...
sense, make disclosure, make full disclosure.
Yeah.
I'm not convinced you need to, but you would make disclosure, and you'd simply say that the buyer buys it, warts and all.
Yes, well, the agent says they'd bulldoze the house anyway because it's rubbish and put up flats or something,
Yes.
So probably that would solve the problem in a sense.
Well, yes, but you're worried about the sale, not what they do after the sale.
Yeah,
Overcome it by including it in the contract.
Okay, thanks very much.
Well, thanks, Bill.
Thank you, Bill.
Bill in Northcote. Cass is in Williamstown, if I can just find
The button.
Cass's line. Hello, Cass. Oh, hang on. Hello, Cass.
Hello.
Hello.
Hello. Yes, look, I've been in a long-term relationship with my partner. When we met, I owned a property. We lived in that for several years. We then sold that property and we bought another property together. Now,
And did you buy as joint tenants or tenants in common?
joint.
Okay.
Right. And my partner has never divorced his wife.
Yes.
My query is, could his wife or his siblings make a claim against this property?
Well,
If I predecease my partner.
the strict answer is siblings no, wife yes. But you've got to distinguish between the right to make a claim and the prospects of succeeding in the claim. Now, wives or spouses or domestic partners are included in the classes of people who can make a claim against an estate. So because they're not divorced, yes, she can make a claim. Okay?
That's pretty clear cut. Thank you, David.
But
Hang on, Cass.
on the basis of no financial interaction for the last 40 years, I just don't see that there's any basis for a claim succeeding.
Okay.
So what you're saying is she's entitled to put in a claim, but the prospect of it being successful is limited.
In order to make a claim, you have to be an eligible person. Spouse and domestic partners are eligible persons by right, okay? But what they need to do is they need to establish that Cass's partner has a moral obligation or responsibility to provide for this person who was his partner 40 years ago, in circumstances where there's likely to have been no financial interaction for 40 years.
So you think that what you're telling me is there could be a claim made, but you don't think it would be terribly successful?
I just, on the assumption of no interaction for 40 years, I don't see it getting up at all.
All right.
Thank you, David.
Okay.
Thanks, Cass.
Thank you, Cass.
Cass in Williamstown. Let's just jump back to trees and stormwater drains. Bran is with us. Hello, Bran.
Yes, good morning. How are you going?
All right, you've been having an argument with your council over storm drains, is that right?
Yeah, my arguments commenced with council only recently. I've actually taken up the matter initially with my insurer, which is about 3 years ago. We're going back and forth. Now, the latest of my issue is insurer has advised that they can take up the issue now with council as the damage has occurred again. So after 3 years, I've got damage to my stormwater, again because of tree roots.
Yes.
And only now are council getting involved. My initial claim has been made against my insurer, and we've been dealing with that for a number of years now. So, yes, just wanted to let the previous caller know that, well, maybe worthwhile taking it up with the insurer as well, as they'll probably be able to help out a little bit more.
Okay, so make a claim on his insurance policy and just sidestep the council entirely. But you're telling me that in the event of a second event, your insurer is taking it up with council, are you?
Correct, and that's the feedback I got from my insurer. Only after the second incident, or any reoccurring incident,
Okay.
that they can take it up with council and then make a claim against them.
All right, that gives me some homework for summer. Thank you, Bram.
All right, thanks, Bran. Just quickly, Jane, we'll squeeze Jane in before we head off to the newsroom. Jane, good morning.
Good morning.
Good morning, Jane.
Hi, David. I've got my will has my two daughters as my financial and medical power of attorney.
So you've got powers of attorney. Your will is something different.
Oh, okay.
All right. The will starts when you die. The powers of attorney before you die.
Okay.
Yep.
I'm due to have an operation, and I'm estranged from my daughters.
Yes.
Can I do a stat deck naming someone else as my medical power of attorney?
No, you make a new medical treatment power of attorney, and you advise your daughters that you've cancelled theirs and who the new one is.
But I'm on a disability support pension.
The forms that you need, Jane, are in the law handbook, and you can handwrite them. Mm-hmm. So if you look at the lawhandbook.net.au at your local library, lawhandbook.net.au, you can look at the forms, and they don't need to be pre-printed. You can handwrite them.
Okay.
And your new so you do 2 documents. The first one is addressed to your daughters, and you say, I revoke the power of attorney that I gave you on such and such a date. You do that in writing. You then do a new power of attorney that appoints your new agent for medical treatment purposes. And remember, it needs to be signed by you in the presence of 2 witnesses, and one of the witnesses needs to be a person who can take a statutory declaration in Victoria.
All right. Jane, thank you for your call. David, thank you for all your time and all your input. I'm sure the listeners thank you as well.
Excellent.
And let me thank you for everyone here for all of this year once again.
Thank you.
So thank you.
And we'll see you in the new year.
We will indeed. David Whiting, Melbourne solicitor, and he comes into the studios here at ABC Radio Melbourne regularly. And this morning, Regional Victoria has had a chance to listen to some of the legal issues and advice coming through as well.